Welcome back. I'm glad you're still with us here on Morning at NTV. I was doing the back end and I was looking at how elaborate some of the aspects that we are going to be talking about next are. And no doubt, I'm glad that we have a very able and eminent individual who will be breaking down some of these aspects. For the start, we shall be taking note of alternative dispute resolution and the case settlement week that is up by the judiciary. It was announced that the alternative dispute resolution or ADR week will begin on August the 5th to the 9th, aiming to resolve pending cases through mediation and negotiation, as well as promoting a more efficient and people-centered justice system. But before I introduce my guest, just a preamble on the alternative dispute resolution or ADR that is often used to describe a wide variety of dispute resolution mechanisms that are short of or alternative to full-scale court processes. Despite dispute resolution outside of courts is not new, societies world over have long used these judicial indigenous methods to resolve conflict. What is new is the extensive promotion and proliferation of ADR models, wider use of court-connected ADR, and the increasing use of ADR as a tool to realize goals broader than the settlement of specific disputes. We are now joined by James Eremye Mawanda, the spokesperson of the Judiciary. Many thanks for joining us.
Thank you for hosting me too.
This is no doubt one of the initiatives that many within the Judiciary are looking forward to, but I think the public must also be in anticipatory mood, not so?
Yeah, absolutely.
What's going to be happening?
Of course, I want to greet you, good morning, viewers, and I bring you greetings from the Judiciary, your servants, to ensure the administration of justice is achieved. And I bring you this important aspect of ADR and the settlement week, which is starting next week from the 5th to the 9th of August. Our people should know that the judiciary has gone and has always been on the drawing board to design interventions that will help case management. Of course, constrained with the heavy caseload and also backlog, we have to come back and design interventions amongst many. But we have a very rich and beautiful approach, which is alternative dispute resolution. You may even say it is the African justice system.
Yeah.
Before this formal system was brought into our legal system, we had the African way we used to solve disputes. And we have recognized the immense advantages it has in terms of one, reducing caseloads which go into the mainstream formal system, and also two, reducing conflicts amongst persons who are in the conflict area, and also building positive interactions between disputants. You will know very well that when we sit together as a brother and we discuss matters, oftentimes we remain friends.
No doubt, no doubt.
When we go the other way, you will always hear somebody dissatisfied and lots of accusations. So we are mainstreaming alternative dispute resolution mechanisms, especially mediation. And so the public, our court users, please let us come together. Let us embrace this innovation. It is so good, and we have lined up very professional people who are mediators, and they are ready to help you. And I want to thank the Honorable Chief Justice, who recently appointed the court annexed mediators, who include our very respectable retired judicial officers. You will find these judges who you know very well coming up, and they have said, let us come back and help our institution, even if we are now retired.
That's right.
So that we can help our people resolve these disputes in so much big numbers. And that's our target. And so today we want to talk about the case settlement week, and how we would like participants or actors to come and join hands.
All right. This one takes me back to a month or two ago when there was an interface between judicial officers and the public at Kololo. I don't know how that event plays into this one, or whether this one is a broader engagement when it comes to the ability or the opportunity for feedback to flow between the judiciary and the public, but also help us understand specifically how ADR, which is of course alternative dispute resolution, is being onboarded. I've always asked questions, if two brothers are antagonizing and the formal court system has is either a sentence and a case has been heard, but these two, or the society or the environment, the people around them, are willing to go the traditional way, I don't know how flexible the formal system is at letting the alternative dispute resolution take the course of the day.
Thank you. That's a very pregnant question. But one, what was in Kololo was a national court open day.
National court open day.
It was a national court open day where we focused on high court divisions in Kampala to give an opportunity to the public to have that public accountability.
That's right.
On what we are doing and the demystification of the processes in those courts, the high court divisions, the Court of Appeal, and the Supreme Court. It was a very wonderful moment when the public can now freely interact with the appellate courts, right from the High Court. This particular aspect of the settlement week, we are mainstreaming mediation, which is a form of ADR, a form of alternative dispute resolution. Under the Constitution, the courts are mandated, in Article 126, thereabout, to promote ADR. So it is something we want now to amplify further and sell to the public to appreciate it, that even in the formal courts, ADR is an integral part of it.
That is right.
And we are starting with the cases which are already in our system. We have them. We have identified them ourselves. And we have talked to the lawyers who represent the parties. Yesterday, the Honorable Deputy Chief Justice was having a conversation with Uganda Law Society on specifically the case settlement week, trying to ask them to take back the message to the parties in these cases. Honestly, you look at a case and analyze it and you wonder why really it is before court. And then you have this conviction that if somebody, an independent arbiter between this person was involved, this case would have been there. That's the advantage you want to take. And we have already asked parties to come forth, asked the different registries in the pilot courts that we are piloting this case settlement week to sell this product to our people so that they can register for the case settlement week. And at the end of the day, we are lining up mediators. These are court annex mediators. And the courts will pay the mediators, so there is no worry. Sometimes people think that when you see they send you to mediation, then you must pay. These are court and mediators. So we are onboarding mediation in civil litigation, okay, in the pilot courts. Much of the courts in Kampala, the divisions which are civil, because of the civil vacation which we want to take advantage of and do these mediations, okay, are participating. Okay. The lower courts we have Mengo and Machindia. Okay, because those are the chief magistrates courts there. Without we can also do that. But I want to also tell you that we have also asked all other courts, if your case is in any other court other than the pilot courts, and you would want to be on this program of the case settlement week, we have asked the judges there, the registrars, to ensure they attend to you. Okay. So we are mainstreaming mediation, and we want our people to come and partake of the wonderful advantages that mediation brings in. And I want to assure you, I will come back here to give you statistics.
Oh, wow.
How many we have
we'll be glad to hear that.
handled, yes.
Okay.
We are really focused, and we want to ensure that our people can benefit from alternative dispute resolution.
All right, before we continue with this particular discussion, you talked about the taking advantage of civil vacation.
Yeah.
There are Ugandans out there who get confused when they say court is on vacation. What is not being heard? What is being heard? Quickly, before we continue with this.
Somebody asked me, now that you are going on vacation, are you going to the Bahamas? Because it's vacation, you know.
So what really happens?
The courts, under the law, we have got the court vacation rules, okay, which ideally intended to allow for courts to go into recess. You have had Parliament going into recess.
That's right.
You have had all people have a time to go
take a break.
Take a break.
Yeah.
Now this break that we are talking about commences the 15th of July to the 15th of August.
Of August, yeah.
Now it's 30 days in between. Okay, what do we do during that time? We take a break of civil matters. The hearing and trials of civil matters are put on hold, but registration thereof and other administrative aspects in the case management continue, but just the hearing of those matters stops to allow a judicial officer, okay, who has accumulated several decisions to make, to retreat and have them written, and when he returns, he delivers that. He delivers that. It's a check and a step within our procedure and the court management that you should not accumulate continuously without a break for you to be able to write and deliver decisions. Anyway, criminal cases, those ones continue because of the liberties and rights involved. So with the criminal cases, the courts continue handling those matters.
All right. Yes. Thank you for that clarification. Now let's return to alternative dispute resolution. I had asked the question earlier that in the case where parties are willing to resort to the ADR model, but when the formal law or system has occasioned a sentence upon one person or one party in that particular dispute, can the formal court system allow for the ADR to take precedent?
If I understood you well, a formal court has already made a decision.
There could be a hearing ongoing, and then there is the possibility that this particular case, or for example elders, so to speak, have advised that instead of continuing this hearing, please come and let's sit down over some calabash, and then we ensure this thing is settled.
Exactly, that is what ADR is all about. Any matter at any stage before judgment in the court, as long as the parties express a need to be allowed to get out of court to discuss, talk under a tree, go before a pastor, go before the clan.
Consult an oracle.
I don't know how effective that will be. But once you're in court, as long as your case has not been decided, a judgment has not been delivered, you are free to ask for ADR. And the court will always, and by the way, the court has gone ahead even not to wait to be asked. The court has heard your case, has listened to your case, or has perused your record. And in his own opinion, believes that no, this is a case suitable for, the court will advise the parties, will advise counsel and say, counsel, as far as this court is concerned, this matter should first go for mediation. I foresee, and I will give reasons as a judge. I will tell the parties why. These parties, you see, want a solution.
That's right.
They don't want these rigors, adversarial approach systems, which we have been trained to at law school and the law development center. So at any opportune time when the court suggests alternative dispute resolution and explains it, okay, and gives the advantages to the parties, I want to assure you, parties will always want to go for ADR. Of course, there are some hardy parties who want to say, me, I want the court to decide. But still, our mediators and our judicial officers have been skilled enough to know how to manage those complicated cases.
Allow me ask a very genuinely naive question. When it comes to case settlement, is ADR a subset of out-of-court settlement?
ADR, alternative dispute resolution, okay, is a diversion from formal adjudication, from the adversarial approach. When a matter is referred to alternative dispute resolution, specifically there are many other forms, but we have mediation, for instance, where a mediator will be part of the group and will assist these parties, okay, to discuss and reach an amicable settlement. Okay, there are other forms. In criminal, we have plea bargaining, we have reconciliation. Parties can be advised to look at reconciliation and reconcile them. We have arbitration, we have so many other forms, okay? But for mediation specifically, when parties are taken out and assisted to reach a settlement, that settlement is brought back to the court. And it is referred to as a consent settlement. And the court will adopt it and issue what we call a consent judgment for the parties, meaning that the parties have agreed. And for as long as what they agreed to is not illegal or unlawful, the court will embrace it. And that will be the judgment of the court.
I would be remiss if I do not pay attention to the reality of the time. We've seen protests going on and arrests have been conducted, and some of the individuals arrested, their lawyers and activists have reasoned that the cases for which they were remanded, many of them are not really substantial, including but not limited to being idle and disorderly and being a public nuisance. At what point is the state ready to consider alternative dispute resolution in cases where, for example, activists find themselves in the throes of the state machinery?
Oh, well, you have asked a very intriguing question. Because one, you talk about protesters, you talk about opinions of advocates, okay, and then you also bring in ADR, okay. But I want to, first of all, I want to make that clarification, because there is a lot of misconception out there, and the public is not being guided well, or is not being given the true information.
That's right.
Yes. protests occur in many jurisdictions and democracies, okay? However, in such situations, there are key actors who manage law and order, peace and security. In those situations, the judiciary does not manage security. For instance, the judiciary does not keep law and order on the streets. So it is our mandate, it's the mandate of other agencies like the police and other security organs. And where there are cases that they think have been committed, they have a whole directorate of public prosecutions. And the director of public prosecution, through her officers, will look through those matters and decide whether to prosecute or not. Still, the judiciary is not there. Remember, the core mandate of the judiciary, and that content is an impartial arbiter. We are on the receiving side.
On the receiving side.
We don't descend into that arena.
Okay, maybe
we don't become witnesses to our own cause.
Let me contextualize it again. And this one is specifically to my understanding earlier when you said that a magistrate, a judicial officer, might be compelled to advise parties to settle this through mediation. If we have a magistrate who has a case of idle and disorderly public nuisance before him, it is not security, it's not treason, it's not...
I was getting there.
All right.
But I first wanted to remove the fallacies and the confusion.
That's understandable.
People are trying to create around, and that's why we have seen some of these headlines that judiciary on trial. Very unfortunate. The judiciary is not on trial.
Yeah.
The judiciary is actually doing its mandate. We are independently exercising our work. What is lacking is for the public, and I want to agree with them that they need answers sometimes. And that's why we should come often on media and explain these things. That the judiciary will receive all manner of cases at their desk. And the judicial officers, the magistrates, when they receive these matters, we expect two things. Okay? We expect the person who is bringing the matter to appear before the court. Okay? We expect the person accused to appear before the court with or without his advocate. In this particular case, we are happy that there are even advocates involved. So we have prosecutor, we have accused and counsel.
Yeah.
And the judicial officer will raise the issues and say, this is what I have before me. What do you have to say? And anyone who has any points of law trace, that's the point. They would raise that, you know what, there is this issue, there's that issue, and the court will decide on
at that point.
But before, when protests are going on and people are being arrested and somebody is demanding that the judiciary should come out, what should the judiciary come out to do? The judiciary makes pronouncements in judgment.
All right, very quickly.
In rulings. But let me tell you the last bit.
Please do, because I have a very last one.
Criminal matters. Yeah. Criminal matters that are before our judicial officers. And the judicial officer feels that these are matters that I talked of reconciliation. I talked of plea bargain. Those are forms of ADR. The judicial officer will always advise the parties. And they will be sorted.
There are Ugandans who are asking the question, why are judges and magistrates very quick to work when the state is up against the people, but sometimes conveniently out of office when the people want justice dispensed? For example, within 2 hours of the protests, charges were slapped on activists. They were effectively remanded. And we've had other areas where a Ugandan wants justice, and a justice or judge or judicial officer is conveniently indisposed out of office, and then the case is continuously disposed.
I have read a post which he has alluded to those facts, and I know the particular court even in which they were talking about. But I want to say that, like I have mentioned earlier, arrests and charging people is within the mandate of the police and
the police and the other forces.
How soon they process their the suspects to court, okay, is really something court cannot control. Because as you saw, there are so many of them, and they were produced quite late before the court, and the court must read charges to each and every individual person, and in line time goes, and perhaps there is no time for other processes to continue, but remanding them for the next convenient date. But two, the particular issue of conveniently being indisposed is a wrong information.
Perception.
Or perception.
Yeah, the information
because
is there.
In that particular case which happened at Buganda Road, for instance, okay, the judicial officer was attending a training, and we are onboarding equally ECMIS, Electronic Court Case Management System, and we had a trainer's training for those courts, and Buganda Road is one which is migrating to handling civil cases. So we had a very critical training at that moment, and the judicial officer had to attend that training. He was officially on training.
Thank you for making that clarification.
So I want the people to have comfort and confidence. We don't do anything deliberately to frustrate the rights of Ugandans.
All right. James Eremye, Jimmy Mawanda, spokesperson of the Judiciary, many thanks for that perspective, but also speaking to us about the case settlement week that will be happening on August 5th through to August the 9th. That will do it for our conversation. Many thanks. Let's now go to our man on the ground, Ivan K. Walunyolo. The Entebbe people are very enthusiastic and in anticipatory mood ahead of the coronation anniversary for the King of Buganda. Ivan, a very good morning. All right, so I think Ivan will be coming to us a little bit shortly after this break. Do stay with us. There's a lot to listen to, especially when it comes to the sentiment of the subjects of the king when it comes to matters coronation.